versus Mason Pechette, 23-200 FY. And People versus Erin Buchholz, 23-199 FY. And Mr. Allen is here from Buchholz.
Yes, Your Honor.
And Mr. Holman is here for Mr. Pechette.
Yes, thank
Mr.
you.
Bahani's here for the people. Mr. Morosky is here for the video. On behalf of Mr. Berry, Ms. Buchholz is here, Mr. Berry's here, and Mr. Pechette is not here of his own volition, is that right?
That's right, yeah.
He's excused.
Thank you, yes.
And matters before the court on the motion to, is the people's motion to reopen proofs in the preliminary examination, which was filed on August 29. The defendant's response was filed on September 8, 2023, and the court received today defendant's joint motion to dismiss for prosecutorial misconduct or in the alternative to suppress. That was received today by the court, September 11. And Mr. Bahani, have you received that motion?
Yes, Your Honor.
And are you able to proceed today or not? I mean, you don't,
I'm able to proceed on my original motion that was calendared for today, Your Honor.
okay. And Mr. Allen, what's your position with regard to not having met the notice requirement, which would require that the joint motion to dismiss for prosecutorial misconduct would be heard at a different time, or do you believe that they're inextricably intertwined to the extent that we need to address them simultaneously?
I believe so, Your Honor. If the evidence is suppressed, obviously that changes Mr. Bahani's motion. I apologize to the court that we got it filed last week, but I didn't know about the subpoena until the motion was filed, and our initial effort was to respond to the motion.
When you say filed last week, on the joint motion, we just got that today.
You got it today. I filed it on Friday, Your Honor.
Okay.
Late on Friday, but
Yeah, it just made its way to the.
I understand that.
So, and honestly, I haven't read it because I've been busy since 8:45 this morning. nonstop.
Understood, Your Honor.
So, Mr. Bahani, your position?
Your Honor, I don't think they're related. The crux of Mr. Allen's motion that the people received this morning is that the people didn't provide any notice of the subpoenas for attorney-client records after privilege was waived during the preliminary examination. The fact of the matter is we did. We're happy to respond to his motion. We're happy to file the proof of service that shows that we did provide the notice of subpoenas and proof of service to Mr. Morosky. This case has not been consolidated. It's been consolidated at the preliminary exam stage for the court's economy, but the subpoena was issued under Mr. Berry's case number, and the subpoena was issued for records pertaining to Mr. Berry's information.
But it was never served on him, is that correct?
It was served on Mr. Morosky. The copies were served on Mr. Morosky, as well as the subpoenas for documents. So we're happy to respond at the court's discretion.
Your Honor, if I may respond to that. Mr. Morosky can certainly respond for himself, but it's my understanding that Mr. Morosky was not served with the subpoena.
Well, Your Honor, why doesn't Mr. Morosky respond for himself?
I'm going to ask it too. Mr. Morosky, what's your position with regard to this latest motion with regard to the subpoena?
Your Honor, based on the subpoena, I did receive notice of a subpoena on August 21st. It was an email from Ms. Krug. It was relating to a whole other matter. It was relating to a subpoena of a video for a probate matter, Your Honor. I did not receive the subpoena regarding that Mr. Bahani filed regarding Mr. Berry's file and his civil attorneys, Your Honor.
Have you ever seen a subpoena for Mr. Berry for his for the production of documents? It was for subpoena ducis tecum, right?
Yes, Your Honor.
Okay. Did you ever see a subpoena ducis tecum from the prosecutor's office regarding Mr. Berry's records?
I did see that subpoena after it was filed.
And
on
when-
Mr. O'Mara,
and-
and then that, I received an email with both of the disclosures from Mr. Rooney and Mr. O'Mara.
So
And that,
so you received it after the preliminary examination date, correct?
yes, Your Honor.
Okay.
And it was August 25th where I received the response from Mr. O'Mara and Mr. Rooney regarding the documents that were released to Mr. Bahani from the subpoena.
Your Honor, I personally filed a copy of each subpoena with the proof of service in Mr. Morosky's mailbox in this courthouse per standard procedure.
And so, did you receive those documents, the subpoenas, from your courthouse mailbox? To your
I
knowledge?
did not, Your Honor.
And you personally put them in the mailbox?
I personally put them in the mailbox.
What date?
On the 21st of August, the same date that I served Mr. Rudy personally, and that Ms. Krug served Mr. O'Mara via email.
Okay, so, somehow, Mr. Morosky, you became aware of the subpoena, duces tecum, and then, and that was with regard to responding to the motion to reopen, correct? Or was it before? I must be confused.
No, Your Honor, both of these things happen relatively quickly within one another. So at the preliminary examination, once Mr. O'Mara and Mr. Rooney testified, the people heard information that we, as I pointed out in today's motion, that we
Right.
never would have sought nor never would have received. But after privilege was
Waived.
waived, this corroborated information that we had received from Mr. Salins, but only had one side of the story, that coming from Mr. Salins. Therefore, we issued a subpoena on the 21st, which was just the Monday following the
Yeah.
preliminary examination.
So, that's exactly what I understood the case to be.
Very good.
So, Mr. Hallman, anything you'd like to add?
Well, just for the record, Your Honor.
And you can stay seated in this
Okay,
court.
thank you, Your Honor. You do have it exactly correct, but I want to be, I think, clear and not to correct anyone.
Go ahead.
But we have the preliminary exam on, I believe, the 17th, which is a Friday, and Mr. Rooney and Mr. O'Mara were served via subpoena on the 21st. Mr. Morowski was not
Who
served
subpoenaed the
by
lawyers?
the people.
Did you subpoena the lawyers to appear at the preliminary examination?
No, Your Honor.
Right.
No, that's, I'm
You're
sorry.
talking, this is after
After
the
the
exam.
preliminary exam,
He does the subpoena, duces tecum, it gets served on O'Mara and,
Rooney,
right.
Mr. Morowski does not receive a copy of the subpoena at that point. He's
Hold
not.
on, you're saying that you served Mr. Morosky with copies of the subpoena for Rooney and,
Yes, Your Honor. I have the proof of service that was
All
stapled
right.
to the two
All right.
copies of the
and did you
of the
provide,
document.
did you provide copies of the subpoena to Mr. Allen and Mr.?
No, Your Honor.
Okay, because. they-
Because this case has not been consolidated for trial.
All right, so do you have any problem doing that? I mean, is it an issue still?
Yes, Your Honor. I mean, there is a dispute between Mr. Morosky and Mr. Pahaney over whether the subpoena was in fact served. Mr. Morosky is saying that Mr. Pahaney is not being forthright with the court, I believe, in saying that he served the subpoena. But he knew that the contents of that subpoena, or the response to that subpoena, would arguably impact the preliminary examination when he sent them, because the very first thing that he did after he received the documents was to move the court to reopen the preliminary examination, not just of Mr. Berry, but of my client and Mr. Hallman's client as well. It's it's underhanded at best, even if he did serve the subpoena in the mailbox. And I'm not sure how that works in this courthouse. Mr. Morosky is saying that he didn't get it. Mr. Pahaney is saying that he did. One of them is, unless there's a person who can raid mailboxes in the courthouse.
That's entirely possible, actually, since the mailbox sits out in the lobby, the openings for the mail faces a wall, it's virtually completely unsecured, correct?
It is,
I
Your
mean,
Honor.
there's video. We could, but I'm not at all interested in getting the IT department to queue up some video for the past 10 days or whatever it is, but
I would think that that's warranted in this instance, Your Honor. This is, I think, we are
hang on a
subpoenaing
second.
it.
So, with regard to the underhandedness, I mean, Mr. Pahani is correct, the cases aren't officially consolidated. They are consolidated for the preliminary examination. I made it known we're having the exam in all three defendants' cases because we have common witnesses and common evidence and all of those things. Whether or not, if the case goes to trial, it will be consolidated by the trial court, circuit court, I have no clue. But my point is that at the preliminary examination, is my understanding, Mr. Pahani, that you did not know that the two lawyers were going to testify, is that correct?
I did not know for
Okay.
certain, Your Honor.
Okay, now, didn't know for certain, whatever it was, so they testify, and he's not entitled to notice either. You can bring your witnesses to an exam, no problem. So the lawyers testify as they did, and based upon their testimony, it seems to me, Mr. Pahani says, well, I'm going to look into that a little bit further. Somehow talks to Mr. Salins, gets what he believes is different information, and now is asking to reopen the proofs. That just doesn't seem surprising to me at all. I mean, I haven't issued my opinion. The court rules allow evidence to be reopened. I mean, what's underhanded?
If the evidence is going to be used in the preliminary examination, Your Honor, I'm entitled to it. I'm entitled to the subpoena. It's an
Okay.
order of this court. And
So-
you've stated that the cases are consolidated for purposes of the preliminary examination. It should have come to
Any
me.
objection to giving the copy of the subpoena?
I'll happily give him a copy of the subpoena, and in fact, Your Honor, I've already given him a copy of everything that I got as a result of the subpoena, but if he wants a piece of paper that is the subpoena, I can happily give him
Well,
a copy.
let's do
Judge.
this, so that we can possibly proceed, and if you're not able to proceed, I respect that, but if Mr. Pahani gives counsel copies of the subpoena duces tecum that Mr. Morosky didn't get, apparently, together with everything you got from the subpoena, the records, can you give them copies in about 5 minutes?
We have them, Your Honor.
Oh, so you got them?
We have the documents. I mean, that's how we found out that there was a subpoena in the first place, was the documents came to us. But we're entitled to notice, and we're entitled to object.
Notice to what?
Notice of the subpoena so that we can object. We're supposed to get the subpoena before the documents are produced. Not after they're produced. That doesn't give us the opportunity to object to the subpoena. I mean, it's lawyer 101 that when you subpoena documents for a proceeding, they go to all counsel. It is an order of the court, and all counsel are
Let me ask
entitled to
you
order of the
this,
court.
let me ask you this. Mr. Pahani, anything in the documents received pursuant to the subpoena, any of those things inculpatory or contradictory?
Somewhat contradictory, Your Honor, to the testimony that
Of
was
the
delivered.
lawyers?
Yes.
Sorry, I interrupted. So what are you asking for, Mr. Allen? What do you want to do?
Well, Your Honor, if we're going to go forward with the motion that Mr. Pahaney had motioned up today, we can get into the substance of what's in the documents because they're irrelevant. And Mr. Salin's testimony is wholly irrelevant to the evidence that was propounded at the preliminary examination. Mr. Salins has submitted an affidavit in this case. Nothing in that affidavit contradicts what either Mr. Rooney or Mr. O'Mara testified to at the preliminary examination, and there's an email in there that references a mutual agreement that we don't know whether it made it to Mr. Berry or not. That information, it's a conversation between Mr. Berry and Mr. Salins and Mr. Berry's attorney, but none of that contradicts the fact that both of those attorneys advised Mr. Berry of the very obvious fact that people are never going to be able to overcome, is that Mr. Berry was a joint tenant with full rights to survivorship, had a right to be on the property. Therefore, this case cannot be brought as a home invasion. Period. None of the exceptions are met. He can brief it, he can call Mr. Salins all he wants, but it isn't going to change the fact that Mr. Berry had a right to be on the premises that night.
And if I may, Your Honor, it also must be said, you asked what is the underhandedness. We included as Exhibit A in our response Mr. Pahaney again is saying that he didn't know about Mr. O'Mara and he didn't know about Mr. Rooney.
What he said was that he wasn't sure that they were going to whether they were going to testify. It sounded to me as though he said he knew of their involvement or some role here, but he didn't know they were going to testify at the exam.
And that is my point, Your Honor. We did let him know on Wednesday before the exam. We included it, the email and as Exhibit A to our response that the only witnesses we had planned to produce, besides the witnesses he included in an email to us, were in fact Mr. O'Mara and Mr. Rooney. And so to address his argument that he was not aware that they would be testifying, it was testimony that he was surprised to hear. It's not accurate, Your Honor, that's all.
Your Honor, can I respond to that?
Go ahead.
Since I'm the one getting accused of all the misconduct.
Go ahead.
But Exhibit A is before the court, and in relevant part, the email from Mr. Allen reads, in addition, the list of probable defense witnesses includes Dallas Rooney and Kyle O'Mara. I believe Mr. Morosky has them as his witnesses and has, I think, secured their voluntary attendance. He can advise whether they require a subpoena as he has been in contact with both. That's not very certain, Your Honor, and that's why until the day of the exam when these witnesses were called, I didn't know whether they would be there or not. That's the Exhibit A that Mr. Hallman's referring to that seems to be a definitive response that these people were on his witness list.
And
I said probable, Your Honor, that they are probable witnesses, which should have put Mr. Pahaney on notice. I mean, if I would have gotten notice of probable witnesses and didn't prepare for them at preliminary examination, I wouldn't be before this court asking to reopen the proofs here because I wasn't prepared.
It's not a lack of preparation, Your Honor. Rather, it's the waiver of attorney-client privilege and the testimony that those witnesses offered that there's no way the people could have been prepared for but for the fact that that privilege was waived, we never would have received the information that we did.
Your Honor, it's true, there was a waiver of privilege at the hearing
exam.
as to what Mr. Rooney and Mr. O'Mara were testifying to. Okay? If Mr. Pahaney believed that that waiver was sufficient to get into Mr. O'Mara's file, there was a second waiver signed on the day that Mr. Morosky was in the hospital getting his leg repaired, that was signed by Mr. Berry and reviewed by Mr. O'Mara. There was no second waiver of attorney-client privilege with respect to Mr. Rooney's file, and that, I believe, is the file that has the one communication between he and Mr. Salins about voluntarily staying off the property.
It seems that Mr. Allen believes that attorney-client privilege can be waived piecemeal rather than its entirety, and that's simply not the case, Your Honor. He doesn't get to say, well, I'm going to let him testify about this one thing, but he can't tell you anything about anything else that happens. That's just not how it works. It's akin to a criminal defendant on the stand invoking their Fifth Amendment right at whim for certain questions, but not for others. Once the privilege is waived, it is waived.
Then why did he do it a second time?
What about that,
He
Mr.
did it a second. I mean, if that were true, Your Honor, then why was there a second waiver that he had with Mr. O'Mara? And there was no second waiver with Mr. Rooney. So he knew, or Mr. O'Mara knew, that whatever waiver occurred at the preliminary examination was not sufficient to just turn over wholesale the file. Could he send the county sheriff into the office of the attorneys to toss the office and look for tangible evidence?
Well, nobody asked for a search warrant. I mean, so that's a ridiculous proposition. And Mr. Hallman, your position?
Well, with respect to this particular matter, Your Honor, I was just going to stand on what Mr. Allen has already said. If Mr. Pahaney was going to rest on that attorney-client privilege that was waived during the preliminary exam, he would not have had Mr. O'Mara prepare a second waiver. He did that with intentionality.
What's wrong with that?
It's just an acknowledgement, Your Honor, that the waiver that Mr. Pahaney just argued to this court.
That's your view of it. Another view could be, and I don't have a position yet because I haven't even read the memo because I just got it. But another position is that it's a belt and suspenders type thing, so that if there's argument about waiver after the preliminary examination and the lawyers testify again, it seems to me that if I was a lawyer involved in any kind of litigation, I'd want to nail it down, have a waiver pretty much every time there's going to be testimony.
And then why not secure it for Mr. Rooney as well?
I have no clue.
And, Your Honor,
Maybe-
we've gotten a little bit away from the fact that Mr. Morowski never received the subpoena that gave privy to this information. That's Mr. Berry's attorney.
And there was a waiver in this case, Your Honor, in his case, secured through another lawyer who's not appeared in this case on a day he was in a hospital. I mean,
What's that about, Mr. Mahan?
I don't know, Your Honor.
wh-
I'm
why not,
sure
why
what
not go to
this-
Mr. Morowski
I'm
and
sorry,
say,
could
hey,
you allow me to answer the
I'm sorry,
question,
ma'am.
Counselor?
Go ahead.
I don't know what he's talking about with the second waiver. After the people issued a subpoena, both Mr. O'Mara and Mr. Rooney approached asking for specificity on the records that the people were seeking.
Okay.
I provided that specificity to each attorney in an email that stated just the correspondence file between themselves and Mr. Salins and themselves and Mr. Berry. No work product, nothing that could even be potentially considered work product, solely correspondence by email and paper. If that's the second waiver that counsel's referring to, I'm not certain, but that email was sent to both Mr. O'Mara and Mr. Rooney.
And Your Honor, not Mr. Morowski at any time. Mr. Morowski, despite those emails that could have, any one of them could have allegedly gone to him, he was allegedly served by a piece of paper into his courthouse mailbox. This was everything with Mr. Rooney and O'Mara was done via email, and Mr. Morowski was left off of every one of those communications.
I think any implication of subterfuge is,
And that's not even what I'm implying. I'm implying my clients do not deserve to have this preliminary exam. In particular, Mr. Pechette, who is my client, doesn't deserve to have this preliminary exam opened when we heard the testimony, and then the attempt to reopen it. It behooves us to mention the fact, Your Honor, that the he's raising the argument that it was so shocking to him,
so are
the
you
testimony.
saying that, leaving out Mr. Berry, you're saying that you don't want to open the proofs in respect to the client's case, but you don't have a position as to reopening it with regard to Mr. Berry's case. Is that right? Ma'am, you need to stop gesturing, okay?
Of course.
Just sit there and don't
Okay.
make any faces, thank you. What about that?
I believe that this applies across the board, Your Honor.
Okay.
I mean,
That's the way I would understand it.
if there is going to be evidence that is adduced against my client, I was entitled to that notice.
So when is it that you provided copies of the subpoena and the records that you received as a result of the discussion between you and the lawyers as to particularity?
As soon as I received them, it would have been the Friday following August 21st. I don't know what date that was.
Okay.
But both sets of records were supplied to me by Mr. O'Mara and Mr. Rooney that Friday. I scanned them immediately and sent them out to all three attorneys.
What about the idea, because it seems like there's some holes to fill here, what about the idea that we have the exam, and then based upon the testimony of the two lawyers, the prosecutor says, well, they opened the door, I think I'm entitled to get some more information based upon apparently your discussions with Salins, is that right?
That's correct, Your Honor.
And how is it that you had Mr. Salins how did that information come up? Did he approach you?
He did,
Is that
yes.
an appropriate question?
No, it's not an inappropriate question, Your Honor. Actually, he approached Mr. Rukowski with information that is included in his affidavit. I followed up because this case has been assigned to me, and after further discourse with Mr. Salins, I did not believe it was necessary to call him at the preliminary examination because, again, I did not know that privilege would be waived and that Mr. O'Mara and Mr. Rooney would testify to the effect that they did.
When did you talk to Salins? It was after the exam, right?
Yes, Your Honor.
Yeah. Okay.
He spoke with Mr. Rukowski prior to the exam, but Mr. Rukowski delivered that message to me after the
Did
exam.
Mr. Rakowski tell you anything about what Salins had to say before the exam?
Only that he had information pertaining to his communications with Mr. Rooney and Mr. O'Mara.
Your Honor, that settles. I mean, from my standpoint, notice to Mr. Rakowski is notice to Mr. Pahaney. If they're not communicating, as apparently they aren't, as I've discovered in my own communications with Mr. Pahaney, or with Mr. Rakowski, then that's on them. That's the people's problem. And, you know, hanging this production on the thin sliver of a document being slipped into a public mailbox, and this is the only thing that's gone missing out of the, I mean, I don't know that there are other lawyers that have had things purloined from their mailbox. I believe Mr. Morosky telling the truth. He has no reason to lie about it. He didn't get the subpoena in time to be able to object before production. The whole reason why attorneys are supposed to serve subpoenas on the other attorneys is we have the right to object to the subpoenas.
But he didn't have any subpoenas to give to you before the exam was over.
I'm saying after the exam, Your Honor, he created a subpoena and served it on August 21st, based upon information that Mr. Rakowski received prior to the preliminary exam in the office. And I did not receive any notice that there was any effort to invade the files of those attorneys until Ms. Krug sent the email. I mean, it's funny that I'm entitled to the documents once they're produced, but I'm not entitled to the subpoena. I mean, Ms. Krug didn't serve just Mr. Morosky with those documents. The first thing that happened, he scanned them and sent them to all three of us. Well, if he's going to send the documents to all three of us, we're not entitled to the subpoena that produced those documents beforehand? I've never seen anything like
I
this.
thought you said that you emailed the subpoena and the documents.
No, I emailed the subpoenas, the original hard copies of the subpoenas were served on Mr. Morosky. The documents themselves that were produced as a result of the subpoena were scanned and emailed to all three attorneys.
I still haven't been served with the subpoena, Your Honor.
I know that. I totally understand that.
Because the subpoena was issued in Mr.
I
Berry's
mean, and you
case.
say that, I don't know, you said, have your office served the subpoena on all counsel other than Mr. Morosky?
No, Your Honor. The results of the subpoena, yes. The actual
Results,
copy of
okay.
the subpoena itself, no.
What's your reaction to Mr. Allen's claim that you're entitled to notice as mentioned in his framework?
Well, again, Your Honor, this case is consolidated for the purposes of the preliminary examination for this court's economy, in that you're hearing, rather than hearing the examination 3 times over, you're hearing the same facts and circumstances. However, from our perspective, Your Honor, these are still 3 separate criminal defendants in 3 separate criminal cases. The subpoena was issued in one case, 23-198-FY. That's Mr. Berry's case. Mr. Berry is the individual who waived his attorney-client privilege. Mr. Berry is the individual who hired both Mr. O'Mara and Mr. Rooney, and Mr. Morosky represents Mr. Berry. Therefore, when we issued a subpoena only in Mr. Berry's case, we served it directly on his attorney.
And then, when you got the materials, are you saying you considered it discovery material, so you gave it to all the parties?
Yes, Your Honor, that's
Okay.
exactly what I'm saying.
Your Honor, the first words out of Mr. Pahaney's mouth were that the court consolidated this case for purposes of preliminary examination. It is consolidated for purposes of preliminary examination. And what does he want to do with the information? He wants to use it in a reopened preliminary examination. So, I mean, it's talking out of both sides of his mouth.
They're not technically consolidated. I mean, they aren't co-defendants. They're all in the same room together, but they're not co-defendants. And there's one case number for each file. I guess the case number would continue even if the court entered an order of consolidation. It was consolidated purely for the reasons that I previously alluded to. I think that we need to take a break. I need to read your motion to suppress or otherwise address this issue. I haven't read it, and it's not, we've already probably, it was worthwhile because I learned exactly what the arguments are in general, but chronology. But we're going to adjourn it and we're going to set it for hearing on both motions. In the meantime, you can get